in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption, strict tight as a vice. In this endless trial, we pay the price.
Hey, yo, folks, and welcome. Better late than never, or something of the sort. We know there's been very few replies from the state regarding the defense motions so far, unless they were filed on the dot, Friday evening, end of business day. Now, one of those was the one we couldn't get a hold of on the Friday panel show, where Fani Willis, her reply to not disqualify the prosecutors, but we could only get the front page or the first page. And we were stuck on getting the rest of it. Now I have. So I have the full 9-page motion to go through with you. Did I win a golf tournament? Hey, there's nothing wrong with this. It matches my plant. So hello everybody, and thank you for showing up. Do the YouTube things while I'm setting stuff up here. Thumbs up, you know that. Subscribe if you haven't yet, and yeah, let's start with that. Oh, how have you all been doing? Oh, that's with it. Hi, Christine. Hi, Nurse Shells. Breaking it down with B, JMK, Denise Sells, Flawed and Human. Oh, that's a... Yep. Aren't we all? Julia Corsi. Time is here. Roy Lonsinger, Patty B. Iron Rabbit. Yep. Remember to change from top chat to live so you don't miss out on any good chat. Gwendolyn is here. Serena, hello. T42. And a bunch of yeah, there's a good bunch of you. This isn't my normal stream time by any stretch of the meaning. So, and for you who are at Replay Crew, great to have you here. Every view, every thumbs up, everything counts if you want to help me grow this channel and have more fun with you guys. Fun size is here as well. Hello. But we are here for one thing and one thing only. This one. Oh, let's make it bigger. That's a good one. Okay, let's dive into it, shall we? In the Superior Court of Fulton County, State of Georgia v. Jeffrey Williams et al. Case number this, and Judge Paige Reese Whitaker presiding. State's response to defendant's motion to disqualify lead prosecutors. The state of Georgia by and through Fani Willis. Glad to catch you live. Glad to have you here, and thank you for being a member for 3 whole months. T for 2. Thank you so much. So this, well, since the defense wants to call both Miss Love and Miss Hilton, their boss, Fani Willis, is the one writing this. Now, does this mean that she is the one to argue it in court? I would assume she has to, because Love and Hilton can't speak in their own case. But will she hand it down to maybe one of the other 3 prosecutors at the bench? Maybe. So we will just have to wait and see. But I really want her to be there to try. I really, really want to see her argue this against Judge Whitaker and against Mr. Steele. Hey, Sleep So Famous TV, Lee got here, and yeah. All right. State of Georgia, by and through Fani T. Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in opposition to Defendant Jeffrey Williams' motions to disqualify lead prosecutors, Chief Deputy District Attorney Adrian Love, CDDA Love, and Deputy District Attorney Simone Hilton, DDA, filed on July 10th and July 18th. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendant cites no facts and no law that authorize this honorable court to disqualify either CDDA Love or DDA Hilton. I'm quite sure he did. Let's see here. I actually have that. Don't I? I think I... Hold on here. Bum, bum, bum. I'm quite sure I have. Where did I put it? Dun, dun, dun. I should have. Well, whatever. I'm quite sure they put in the argument why to disqualify these 2 prosecutors. The reason is participation in the ex parte meeting and citing the Georgia Rules of Conduct. So even if the claim that cites no facts and no law, yeah, that's a lie, Miss Willis. That's you lying to the court. That's not a good start. Politicking with me. Where's Gigi? Gigi is around. She's still making herself at home in her new home. So when she's ready to come back and be my first and best moderator, she will. I will not rush her. I will not rush her. Yeah. Hi, Kat. Yeah. The argument is always no argument, nothing cited. I'm quite sure that is false. Hey, Kat, you want to join me? You just had a stream, so maybe not, but I will send you a link anyway, if you want to. Dun, dun, dun. There you go. Now you have the link if you want. If you want to. Okay, no, let me listen. Okay. Patty B. Fani Willis wrote this? Yep. And yeah, this part, defendant cites no facts and no law that authorize this honorable court to disqualify either. Now, here's what's hidden in this argument. It's not that the Fani Willis says they don't cite anything. She just says they don't cite anything that authorize this honorable court to disqualify, which is a bit different. But it's just fun to read it that way because the letter of how it's written, literally, is that the defendant cites no facts and no law that authorize. But that's an opinion. This is just weird writing. Just weird writing. Accordingly, the state respectfully moves this honorable court to deny defendant's motion to disqualify the lead prosecutors. In support of this response in opposition to defendant's motion to disqualify, the state shows this honorable court the following. 1. Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to defendant, the laws of Georgia and the facts of this case mandate this court's denial of defendant's motion to disqualify. First of all, this is a headline is not a paragraph in itself. It should be shortened to the point, and then you go on with the argument, in my opinion. But Fani Willis can do what she pleases, including but not limited to. Yeah, I've been saying jokes about her and Nathan Wade for so long. Do you think I could manage a whole stream without mentioning her lying in court and screwing with a married man? Oh, whoops, I just did. Now, can they get other sources of evidence available? Yeah, well, of course, you have the transcript. But that's not... that's only when the ex parte meeting was on the record. It cannot show what was said outside of the record. For instance, when did you decide to hold this ex parte meeting, and why did you not inform both the court and the defense that you were seeking it? For just as an example, that puts both Love and Hilton above just the transcript. Can they call Miss Bumpus? No. Because her testimony is in the transcript. That's the transcript for Miss Bumpus. And if they want to ask Miss Bumpus, well, they can't ask her about her client, about possible admissions, because there is the the attorney-client privilege. There is a privilege in the way, so they can't call Miss Bumpus. Can they call Woody? Well, yeah, but what's he going to say? Now, this goes to the credibility of the prosecution. Why did they do this? How did they do this? And what was actually said once they were off the record. That is why the defense wants Love and Hilton on the stand. Now it's ultimately up to the judge. It's ultimately up to the judge. In support of his motion to disqualify the lead prosecutors, defendant asserts that, quote, Love and lawyer Hilton have made themselves critical witnesses in this case, end quote. When CDDA Love engaged in text messages with a witness, and when CDDA Love and DDA Hilton participated in a hearing in chambers with a witness and his lawyer regarding contempt proceeding against a witness. Well, these text messages with Woody, that was in the lead up to in the lead up to him testifying, to getting him on the stand and such, where they contacted him directly. Those text messages we haven't seen. We heard Hilton explain about them, but we haven't seen them. And without her on the stand, those are hearsay. So they need her on the stand to verify these are the actual text messages, because they can't trust Woody to be credible on the stand. Or he might just lie. As he said in the transcript, he will lie on the stand. Let's continue. Defendant cites no legal authority in support of his position. I'm quite sure they cited the Georgia Code of Conduct. I'm very certain of that. Hello, Taz. Yeah, she has to verify her phone number. Good point. See, defendant, however, has the heavy burden of proving that disqualification of the lead prosecutors in this case is warranted. See Lewis v. State, 312 Georgia Appeals, blah, 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 blah. Why is this in... okay. Instructing that, quote, it is the burden of the party seeking to disqualify counsel to prove that the extraordinary remedy of disqualification is warranted, end quote. Now they are into shady business again, when they leave out a lot of what that case actually says. I don't have the time right now to go through the Lewis v. State to see what is the but it is an extraordinary remedy. But there are also Brady violations, and they did quote Brady Giglio, both Brady and Giglio. Those are actual case law. So again, Miss Willis, stop lying. It's not, I mean, it's enough that you lie in church, but lying to the court this openly and without shame? Yeah. Hello, Kristen Vasquez. Hello. Good to see you. Defendant doesn't even attempt to meet this burden. Instead, he rests his pleadings on legally and factually unsupported assertions. Oh. A, the hearing in chambers was proper. Oh, go screw yourself, Miss Love. You know this isn't true. Now, what speaks for Prosecutor Love here is the findings of Judge Krause, that she didn't find anything wrong with the ex parte meeting. But there's a lot of people who disagree with that, me included. Defendants asserts without support that CDA Love and DDA Hilton are disqualified as prosecutors in this case because they attended a hearing in chambers that he believes himself entitled to have attended. Defendant argues that the lead prosecutors in attendance at the hearing are disqualified under Georgia Rule of Professional Conduct 3.7a from further prosecuting the case because defendants now needs to examine them about the hearing and what took place. Defendant's argument is not grounded in law. Brady, Giglio, two of the most important case law statutes in U.S. law. We saw it in the Baldwin hearing, in the Baldwin trial. The Brady violation there was enough to not only get a prosecutor disqualified, that judge threw the entire case out. So, not grounded in law. I mean, This is just so wrong, Miss Love. This is just so wrong. The hearing in chambers was about an ongoing contempt proceeding against a witness who, upon motion of the state, has been compelled to testify but refused to do so. We all know that, Miss Love, but it is the content and the fact that it was hidden from the defense in its entirety. Miss Love and Miss Hilton and Judge Glanville conspired together to keep everything a secret until after the trial concluded, and only then release the transcript. That is. And here she just, the hearing was proper. See King v. State, Georgia, blah, blah, blah. Ruling where King had complained, quote, that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify in King's trial and confirming the use and derivative use immunity that would apply that compelled testimony. The hearing appears to not have been a part of the proceedings against King. Do you know what the difference is here, Miss Love? That was the King case was before the witness took the stand. Woody was on the stand, sworn in when this hearing happened. So the King v. State does not apply, in my opinion. The Georgia Supreme Court pointedly recognized in King under circumstances closely resembling those here, I don't agree, that while King might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order compelling the witness to testify in King's trial, or that would suggest that King's rights were the subject matter under consideration, see Williams v. State. On the contrary, the trial court was obligated to consider whether the testimony was necessary to the public interest, a matter which King had no standing to address. Any alleged bias on the witness' part was the proper subject of cross-examination, not grounds for denying the state's request for the order. Again, let's go up to what her claim is here. Under circumstances closely resembling those here. This is plain false. The witness in King was about to testify. He was not on the stand when the ex parte meeting happened. He was not on the stand. Also, they didn't hide the ex parte meeting to the defense. After that ex parte meeting, they notified the defense, we have had this meeting. So it's not closely resembling the Young Thug case, in my opinion. Likewise in Allen v. State. The Allen v. State case is something the prosecution in this case has referenced on occasions. And both Steele and Schott have made claims to the court when Judge Glanville was presiding that they are misrepresenting what is in the Allen case. Likewise in Allen v. State, the Georgia Court of Appeals cited King in support of its holding that the defendant had no standing to contest the grant of use immunity to a witness. The use immunity towards the witness is not what the defense is arguing. This is a straw man argument from the prosecution. It's a pure straw man. Ignore what the defense is actually saying, and just so we will put in this instead and argue against this. But that's not the defense argument about the ex parte hearing. They don't argue against the grant of use immunity to witness. That's not a part of their argument. Under both King and Allen, in-chambers hearing was proper. Defendant had no standing to contest the hearing or to participate in it. Surely defendant does not expect that a proper hearing, which he had no standing to contest or participate in, now somehow provides defendant the right to disqualification of the lead prosecutors who took part in the hearing. Such a position makes no sense. Now, this is gaslighting. This is so condescending. Now, I don't mind shade in a motion or in a brief. What I don't like is gaslighting. That is highly improper. Highly improper. Yes, Dave, I got it. Yeah, I got it. You have a link if you want to. Dave has his Lego stream in about half an hour, where he interviews Andrea Burkhardt. They are building Legos. It's Dave, it's Valhalla Waits, it's Wendy H, and Andrea Burkhardt building Lego and having an interview and just a conversation. Dave says, I'm taking a nap before Lego. Just wanted to jump in and share the stream. Oh, thank you so much. Yeah, if you have a social media, Twitter, X or something, please do share this stream. I don't mind at all. Let's continue. B. Disqualification of the prosecutors would constitute an abuse of this honorable court's discretion, where other sources of evidence about what happened at a hearing are available to defendant and obviate any, quote, need of defendant for either prosecutor's testimony. Jesus Christ, Miss Willis. A headline is not a paragraph. Okay? A headline is not a paragraph. Stop doing this. It's stupid. Let's see what she says. Even if the hearing had not been proper, it wasn't proper. An even bigger hurdle barring disqualification of the prosecutors is the availability to defendants of other sources of evidence of what happened during the hearing. Other sources of... I thought you wrote earlier that they did not present evidence, which they did, the transcript and everything. With some exception, Rules 3.7a of the Rules of Professional Conduct of the State Bar of Georgia provides that, quote, a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. However, the party moving for disqualification of a lawyer under Rule 3.7 has the burden of showing that the lawyer, quote, is likely to be a necessary witness, end quote, by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact and that there is no other evidence available to prove those facts. Problem with the transcript is that it does not tell the entire story. We don't know what happened when Glanville went out in the corridor. We don't know what happened in when Miss Weaver stopped writing. There is discussions happening when they are off the record. Those off the record statements can only be brought in via either Ms. Love or Ms. Hilton. And again, the text messages to to Woody can only be brought in via Ms. Hilton. Unless the prosecution all of a sudden says, we will stipulate to it, which I don't think they will. Which I don't think they will at all. Clough versus Rich Law, Georgia Appeals 2005, citation footnote omitted. Defendant cannot meet that burden. Where's that citation? Is this the citation? Sure. The hearing in chambers was taken down by the court reporter and transcribed. All parties now have the transcript of the hearing in chambers. The transcript clearly identifies those who were present, and that includes sheriff deputies, investigators from the district attorney's office, the witness currently on the stand. Yeah, currently on the stand, and the witness attorney. Indeed, defendant will get to cross-examine the witness at issue himself. The claim here from Ms. Willis is, you have Woody on the stand, you can ask him. I somehow believe the prosecution will wildly object to any statements from Woody where he claims, well, Miss Hilton said, objection, hearsay, correctly. Well, Miss Love said, objection, hearsay. Well, Judge Glanville said, objection, hearsay. So that removes Woody. Let's check with Kayla Bumpus. She has attorney-client privilege against her client. She's off limits. Sheriff deputies and investigators from the district attorney's office. We do not know if they were there the entire time, or if they walked in, walked out, if they were playing on their phones, if they were paying attention. The people in that transcript, the only people who were required to be there and have their words written down is Judge Glanville, Miss Love, Miss Hilton, Kayla Bumpus, and Woody. I already explained. Woody is gone. Kayla is gone. That leaves 3 people who can testify about things that is not in the transcript. Okay? So this falls on its face, in my opinion. And here is some quote. The practice of trial attorneys testifying is not approved by the courts except they were made necessary by the circumstances of the case. One other thing. What knowledge does Hilton and Love have about Mr. By Woody's alleged? You remember from the transcript? I did these crimes from Woody. Does Love and Hilton have knowledge about it? Can only be brought in by them. Can only be brought in by them. Timberlake v. State. The advocate as a witness poses innumerable threats to the integrity and reliability of the judicial process. Courts have properly refused to permit a prosecutor to be called as a defense witness unless there is a compelling need. Citation and punctuation omitted, blah, blah, blah. Trial courts are generally held to have discretion on whether to allow a party to call opposing counsel as witness, on the view that attempting to call opposing counsel to establish some fact that can be readily proved in a different manner should be discouraged. Yeah, I mean, that part I understand. That part I understand. The problem still is in that the transcript does not reflect everything that was said during that meeting. We don't know what was said off the record. We don't know what was said in the hallway. We simply don't know. And there's only 3 people who can testify about that. That's Judge Glanville, Miss Love, Miss Hilton. Goodwin v. State, emphasis added. There is no compelling need for the lead prosecutors to testify, especially given that there are ample other sources of information to establish what occurred at the hearing in chambers. C. Disqualification of prosecutor. Yeah. Again, Miss Love, for the love of everything holy, a headline is not a paragraph. Stop writing like a 6th grader. disqualification of prosecutor Love based on the exchange of text messages with a witness also would constitute an abuse of this honorable court's discretion, where other sources of evidence about the text messages are available to defendant and obviate any need by defendant or CDA Love's testimony. I haven't read this yet, by the way. This is as new to me. You might know more about this than I do if you watched Kat's previous stream. With ample sources of evidence about the text messages being available to defendant, most notably the witness herself. Whom defendant already has examined at trial. Defendant asserts that the text messages also require his examination of CDA Love. Am I missing what text messages? Because there were text messages in contact between Miss Love or Miss Hilton and Woody. But I mean, there is also the text messages has been brought up before in this, but I'm not entirely sure what witness whom defendant already has examined at trial. Are they talking about Miss Bennett? I don't know. Oh, I actually don't know who they are referring to. The witness. With a witness would also. Then why don't they name that witness? The law contradicts the defendant's assertion. See Schaff v. State, noting that, quote, speculation as to the content of an opposing counsel's testimony could not support the disqualification order. The Georgia Court of Appeals had in Schaff v. State. Blah, blah, blah. That the trial court abused its discretion when it disqualified trial counsel on the basis that the trial counsel's testimony was necessary, where the victim made a statement in his presence. Okay. Where the victim made a statement in his presence. But the statement had also been overheard by the victim's mother and by trial counsel's assistant, who could testify to the circumstances surrounding the child's statement. This is a bad example. Yeah, Kat, it's sloppy when I don't even want to specify. And here is this part. They forgot to proofread. Or somebody did. It's Bree. If they don't specify, then they can be fact-checked as easily and proven wrong. Yeah, I mean, this is written in big haste by prosecutor, by Fani Willis. And I overheard by the victim's mother. Although the Schaff court agreed with the trial court's concern, does she mean although the appellate court agreed with the trial court's concern that trial court's counsel's testimony, quote, would be relevant to the jury for determining weight and credibility to decide the child's videotaped recantation, and possibly the preferred method? The Schaff court ultimately concluded that trial counsel's testimony was not necessary to prove any fact related to the video or the circumstances surrounding the video. This court explained that such speculation as to the content of an opposing counsel's testimony could not support a disqualification order. Quote, otherwise, any party could successfully move to disqualify an opposing party by simply averring that the opposing attorney might possess information that is damaging to the attorney's client's case, and therefore that the attorney is likely to be a necessary witness in the moving party's case. To prove of such a tactic would be opening the door to blatant misuse of a rule that already had great potential of abuse. But is that a civil case? I need to check if they're actually citing a civil case. Dun, dun, dun. Let's see here. I'll share this. Okay, this is, let's see, case details. Citing cases. Opinion. Yeah, this is just the disqualification of counsel. Bum, bum, bum. This appeal arises from a legal malpractice suit filed by Walter Clow against attorney Thomas A. Richelo and his law firm. They are citing a civil case, you absolute. They are citing a civil case as an argument to not cat's child hearsay issue. Yeah, and it was in a civil case. For frick's sake. So they didn't find a correct opposition through criminal law, so they are citing a civil case. This is so stupid. Oh, okay. Defendant proffers no information he seeks to gain from CDTA love that he cannot, quote, quite readily get, has already gotten from another source. Disqualification of lead prosecutor under these circumstances would constitute an abuse of this honorable court's discretion. He can't proffer information. This is so stupid. He proffers Mr. Steele, Mr. Williams via Mr. Steele. Clearly said in his motion to disqualify them because they are needed as witnesses, that this is the information we seek, that we believe upon knowledge and information, as they said in the hearing against George Glanville. Remember when I read the Bruce Harvey motion? It was so easy to read because he writes so good. And then you have Mr. Shaw and Mr. Steele, also excellent writers of motions. And then you come to this pile of garbage. This isn't easy to read because there's no flow to it. There's no flow in the information. There's no flow in the how you. When you write something, you should say it out loud before you file it, because then you will hear your mistakes. I do that all the time. And that is one of the main. I got better at writing my files and motions once I started reading poetry, to get a flow of the language. Because if you don't have flow in the language, because the rhythm of it, so to speak. This is the way we talk, and this is the way we write. If you do it like that, it just sounds wrong, doesn't it? You can do it the Obama way. Dun 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 dun. So there are many interesting ways to speak and to write. This is just a mess, in my opinion. And for you who wonder, yes, I'm the whitest guy on the planet. Just said that a black prosecutor doesn't have rhythm. Hey! Let's get back to this faster clock. Defendant's reference to the former trial judge has no bearing on defendant's motion to disqualify. Okay. At least it's just a headline and not an entire paragraph. Although it is not necessary for the present motion, Williams asserts that he wants to call as a witness the chief judge who until recently presided over the trial. Okay. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors are not necessary witnesses. I don't think Miss Willis is the person to oppose this. The person to oppose this is Judge Glanville's attorney, if he have one. Miss Willis can write because she is the employer, or she's the boss of Miss Love and Miss Love and Miss Hilton. She can write motions when in regard to them. She cannot. Oh, Jesus Christ! With this, there is a tiny risk that Miss Willis, if she argues for Judge Glanville, she might have just volunteered to be Judge Glanville's lawyer. That is pure speculation from my part. But I wouldn't be surprised to see this in a reply to this reply. Oh, dude. Oh. What the... Moreover, while at no point did the chief judge comment on the evidence before this jury, he doesn't have to. It appears defendant's primary purpose in calling the chief judge would be to ask him to do just that. Yes, that is how you call witnesses, Miss Love. Congratulations, here's a crayon. Because Judge Glanville is no longer a part of this trial. Once he leaves, they can call him as a witness and ask him this, because now he's just a witness. Oh, for frick's sake. And here she goes again. For the love of all holy, a headline is not a paragraph. There is no evidence to authorize disqualification of the lead prosecutors under the two only generally recognized grounds for disqualification of a prosecutor in Georgia: conflict of interest and forensic misconduct, and defendant does not even purport to request relief on those grounds. Conflict of interest. There is a conflict of interest because they colluded with Judge Glanville to keep this ex parte meeting a secret until after this trial ended. So there is a conflict. There's a clear conflict to testify, Because if it is deemed that they did this ex parte meeting illegally, they can be in trouble. So there is a conflict of interest. And the only way to resolve that conflict of interest, as they are the prosecutors and witnesses and possible witnesses, is to remove them as prosecutors if they are deemed to be necessary witnesses. There lies the conflict of interest. This is basic, Miss Willis. This is basics. Jesus Christ. Defendant does not allege, nor does there exist evidence in this case suggesting that either prosecutor in this case should be disqualified under the two only generally recognized grounds for disqualification. So she repeats herself. She has the header and then she repeats herself. She writes the same thing twice. No, this is Fani Willis who writes this. See, Reed v. State, citing Williams v. State. In McLean v. State, Georgia appeals, the Georgia Court of Appeals recognized that a trial court, considering a defendant's motion to disqualify an elected district attorney or her staff based on alleged misconduct, must, quote, hold those who allege such misconduct to a high standard of proof. Hence, the motions, and then there will be a hearing. We are not at the hearing stage where the defense can, and they have proffered in their motion what they believe is the misconduct. Even assuming for the sake of argument that the allegations set forth in defendant's motion were true, those allegations failed to meet the high standard required to disqualify two lead prosecutors from an ongoing and well-advanced criminal case in the middle of trial. That's an opinion, sure, but Miss Fani Willis' opinions I don't hold in high regard, since she, without hesitation, lies in church. She lied in church in a Martin Luther King sermon about her doings in her relationship with Nathan Wade. If you can lie in church, you can lie to the court. The extraordinary relief defendant Williams seeks is simply unwarranted, and his motion should be denied without any further proceedings. Yet, Fani Willis doesn't want this to be heard in a hearing. She just wants the judge to deny the request without a hearing. Well, there is a possibility that Judge Whitaker says we don't need a hearing on this. There is a possibility. But it's also possible she wants to hear it. Footnote. Additionally, this is not a good... Why does she put this as a footnote? This is a part of her argument. That's not a footnote. That's a continuation of the argument, not an explanation of the... Okay, let's just read it. Additionally, the court should deny the defendant's motion as not being sufficiently particularized in violation of the court's standing scheduling order for criminal cases in Judge Whitaker's division. His motion does not specify with particularity any evidence that supports his desired relief. I believe she is wrong. At best, the defendant has merely cobbled together a broad and barely defined class of allegations to support his theory. But he has utterly failed to explain how such allegation would necessitate or even authorize disqualification. Cat's right. Oh, the cat, not Williams, right. I looked at this like she was sucking up to Whitaker, the footnote. If she does, it's really poorly done, because this is not how you use footnotes. This is the continuation of her argument. This is Here's what she should have written. This should have been written as a headline in, for instance, you have here, as you have D followed by 2. So so this here should have been a headline, and this should have followed under the headline. That's how it should have been written. This is so stupid. Conclusion. For the reasons stated above, it would be an egregious abuse of this honorable court's discretion to disqualify Love and Hilton based solely on the de minimis assertions. This she could have cut out. This is just, I know Latin words. Based solely on the assertions advanced in defendant's motion, especially where there is no evidence of any ground authorizing either prosecutor's disqualification. This court should not abuse its discretion by disqualifying the prosecutors, especially where their June 10th hearing, about which defendant incessantly complains. Oh, stop whining, Miss Willis. Was proper! It was proper, Your Honor! It was proper! Don't throw tantrums in a court filing, Miss Willis. And where there are available to defendant other sources of the information about which he claims to need to examine Love and Hilton at trial. Defendant's efforts to forestall the conclusion of the longest trial in Georgia history. That's on you, Miss Willis, and Miss Love and Miss Hilton, not the defense. By seeking to disqualify the lead prosecutors should be immediately stopped. This honorable court should deny defendant's motion to disqualify the lead prosecutors in this case on the pleadings alone. Respectfully submitted by Fani Willis. Here's a footnote on this. Stating, quote, when the trial was halted on July 1st, over the defense demand for the judge to recuse himself, it has already surpassed this previous longest criminal trial in the state. That trial involving Atlanta public school educators accused of racketeering in a cheating scandal lasted about 8 months. The sole reason, the only reason this trial has lasted for this long is because of the prosecution, not the defense. So her assertion here, don't do this because it's already been a long trial. This is so stupid. Yeah. But that, let's see if there's anything else. Certificate of service. Okay. That was Fani Willis' reply to the motion to disqualify Miss Love and Miss Hilton. And it's poorly written, bad case law. And I believe Judge Whitaker should have Miss Willis trying to argue her position in court against Mr. Steele. Yes, she is blaming the defense for the length of the trial. This is so stupid. All right. I think that is all I have for you all for now. Monday, there will probably be a bunch more filed replies from the state. Because there is a lot of outstanding motions that we haven't seen replies to, which they probably filed on the dot, but it's not gotten into the docket yet. Oh, yeah. Folks, it's good content for me, but it's also very disappointing because when district attorneys files poorly written with bad case law, that reflects bad on the profession of doing law. And I'm a bit offended by the sheer audacity from Ms. Love to submit something this poorly written. And yeah, but that is all I have for you today, folks. I will be sending you over to Dave and Valhalla and Wendy and Andrea Burkhardt, who will have a discussion while they are building Legos. And thank you for being here, folks. Thank you for allowing me to do this. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? I will see you on Monday. Bye-bye.